Well, it is Sunday and I am in the office. I put out a blog article on Friday in our weekly update about an update that was done following the Supreme Court's decision in Commonwealth v. Berry. It has to do with sentencing. Now, obviously, when you hire a criminal defense lawyer, you do not want to be in a position where you're at sentencing. But as we all know, there is always a possibility that you can be convicted following a trial, or your attorney has advised you that a trial probably isn't in your best interest, given the fact that the evidence is overwhelming, and the attorney has negotiated for you, hopefully, a solid plea deal. Now, there's also a thing as far as an open plea, that's an option, but I always advise clients that we're only going to do an open plea if I have a strong understanding of the judge's sentencing philosophy, and also I have a good understanding of where the prosecutor is going to go with it. You should never go into an open plea just because you just think it's the right thing to do based on some type of nothing concrete. It's a very, very risky thing. And so sentencing is a critical part of a criminal case. It's something that a lot of us will have to consider if you are in a position where you've had a criminal case and unfortunately been convicted. So in this situation, the decision in Commonwealth v. Barry has to do with prior arrest. Now, prior arrest can't be introduced during trial as evidence of some type of bad character, but they can be used at sentencing. Well, could have been used at sentencing prior to this case in the Pennsylvania Supreme Court. And the court decided that no longer could that be argued at sentencing. And frequently in a pre-sentence report or pre-sentence investigation, that is typically done because that report generated for the judge, which is given to both the defense and the prosecution, will indicate not only convictions, but prior arrest. And the first thing the prosecutors will point to is a person's long arrest history, if that exists. And whether or not the person was convicted is obviously going to be brought up or should be brought up by the defense lawyer, but the judge heard it. And the judge heard that this person has had 24 prior arrests. And it doesn't matter that they weren't convicted. It doesn't matter the Commonwealth or the state, if it's a out-of-state record, didn't establish guilt beyond a reasonable doubt. The judge, prior to the Barry decision, could use that against the person. And that could lead to a more severe sentence. So the Barry decision, while it's probably not going to make headlines anywhere, you're not going to see it on the internet, probably unless you're really looking around, but it is nevertheless important. It's an important decision if you have a sentencing coming up that you stress this to your lawyer. It is also an important decision if you've recently been sentenced within the last 10 days or last 30 days, you have post-sentence rights, which you should exercise, because based on this decision, the court should relook at sentencing, and it's not guaranteed that your sentence is going to be reduced, but there's a possibility if the court gave those prior arrests any weight, especially if the court mentioned those prior arrests when it provided its reasoning for an aggravated sentence. Obviously, if you received the mitigated sentence, I wouldn't do anything with it. But even there, if you received the mitigated sentence, but in that reasoning, the court did point to some type of prior arrest record, and that was concerning, especially if it was one involving violence, it should be brought to light. So your attorney should be filing a motion with the court to have that reconsidered, or possibly an appeal. If your sentencing is coming up, again, it's something that should be in your attorney's sentencing memorandum. Every attorney, if you're facing a sentence where you're facing any type of jail time or even probation, you should have a sentencing memorandum done. I never liked going into a sentencing without anything and just simply telling the judge, well, judge, here's what you heard at trial, or here's what you heard at the plea. Personally, if I was ever a judge, I would almost make it a requirement that the attorneys had to submit sentencing memorandums, both to protect myself as a judge and also to protect the attorneys, really. Because really, that's important that you provided the court with information regarding mitigation, or in the case of a prosecution, aggravation. But if you have questions, 215-755-9000 in Pennsylvania, 856-793-7429 in New Jersey, the website gambleandlaw.com. As always, a tremendous resource for you and your family. All my books, my blogs, my videos are available there in one convenient format. It's a great resource that I encourage you to read. At this point, we have over 1,000 blogs, hundreds of videos, so a lot of content there that we make available to our clients at no cost. It is Sunday. I know the weather is still pretty nice. I haven't been able to enjoy it just yet, but it is still pretty nice. If you are stopped for suspicion of DUI in Pennsylvania or DUI in New Jersey, do not refuse the chemical test. It'll never help your criminal case. Police officer is going to arrest you. Don't make any statements. Don't give consent to search your person or your property. Those little things will protect you immensely if you are charged with any type of crime, including DWI. But once again, if you have questions, 215-755-9000 in Pennsylvania, 856-793-7429 in New Jersey. Have a great Sunday, and I'll talk to you all very soon. And I'm going to link in the e-update. I'm also going to link in some articles that I wrote on sentencing and things that you need to be concerned about. So have a great Sunday. And again, I'll talk to you soon.